Thank you very much for the kind introduction. Good morning, almost good afternoon, ladies and gentlemen. I'm very honored to speak here today. This is my first visit to Latvia, first visit to Riga. Contrary to the previous speaker, or one of the previous speakers, I can only regret that I have not been studying here, and I may look for a program to apply, maybe. But I'm very grateful for WIPO to have invited me and to the Patent Office to speak about a topic that I have had the honor to watch closely, being a Brussels practitioner, being a long-standing member of the Licensing Executive Society, and in that capacity I have given a little contribution to the directive. I will talk more about it, the genesis of this legal instrument that was published 2 years ago, and that actually the member states should have implemented and put into effect by the 7th of June. So the clock is ticking. I also have some mixed feelings, honestly, to speak on World IP Day about trade secrets. It's a bit ambiguous, because as you know, in Europe, at least the European Commission and the European Directive forces itself at multiple times to state, to confirm that trade secrets are not an intellectual property right. And I personally very firmly believe in that position. But not everyone does that, not all countries agree on that, and certainly not across the channel and across the ocean that opinion is shared. And that also explains the ambiguity in the legal text that I'm going to discuss with you, because the question that remains, has a new IP right been created with this directive or not? I don't think so, but some of the points, some topics that I will highlight can make you wonder if that is not the case. I will focus my presentation, because I was asked to do what can companies do with the Trade Secrets Directive. I will focus my presentation from time to time on specific employment issues, because the major change for companies, or the major steps and actions to be taken by companies to implement the trade secret legislation is most likely on the employment level, on the HR level. So we will first, and this will be the only exercise where I will quote you some legal texts. You will not see many texts on the directive. You will not see I will not go point by point through the directive with you. I'm going to highlight a couple of issues. The identification of trade secrets, the new definition. It's not so new, but from the traditional practice in many member states, such as mine in Belgium, it is really a big departure, a big evolution. I will talk to you about the very, I would say, contentious notion of infringing goods. What is it? I am personally very concerned about that definition. What will the courts will do it? I will go across the ocean. I will make a short comparison with the United States. You may know that it is no coincidence that 6 weeks before the European Parliament adopted the directive, President Obama signed the Federal Trade Secrets Act in the United States. So 2016 was really the year where trade secrets got a lot of legislative attention, and that is no coincidence, and I will explain why. I will then go a little bit deeper into labor law aspects. I will then try to say something about national implementation phase. I'm trying to follow a couple of legislative processes in other countries. I failed a bit to do that because it's a bit opaque. I can talk about Holland, I can talk about my own country, and we will learn later today probably about where you are here in Latvia with the implementation, and then I will try to draw a couple of conclusions. First of all, in perspective, I must really congratulate the people at the Commission and at the legislative body for having made this directive at such a quick speed. It may also explain why the text is not perfect, has not been thoroughly thought through, because it went so fast. But if you compare this with another topic that is dear to my heart, and that's the Unified Patent Court, which after 40 years of pushing and lobbying is still not there. If you imagine that in the summer of 2013, I invited in my office in Brussels 2 representatives of the European Commission. They came from the EU IPO. They were actually people who were working in the trademark and design office, and they had been tasked with thinking about a new legislative instrument to harmonize trade secret law. And they asked stakeholders for ideas, for input. In my office, I organized for LESI in the summer of 2013 a meeting with industry members, with patent attorneys, with lawyers to feed ideas. The Commission needed evidence that because of discrepancy in national trade secret laws, there was actually barriers of trade, that companies hesitated to expand into other countries in the European Union because of lack of adequate trade secret protection. We gave that evidence, and we gave a lot of ideas. I'm not saying that we drafted the directive, but there was a lot of input from industry and from certain stakeholders, such as LESI, to guide these two public officials who then reported back. And this explains also why this directive came to life so quickly. There was a big push from industry. There was a big intention within a few people of the Commission to work very, very hard on this. And then at the very end, in May 2016, in the spring of 2016, just before the directive should have been adopted, a lot of lobbying started for the exceptions. And it's there, I'm afraid, that the text is not very perfect because the exceptions were made for the press, for the labor unions, and it's there, I think, that still a lot of work should be done. And I will come back on that later on. But first of all, let's see why was there a need in the European Union for uniform protection. Trade secret law, and I repeat it, it's not IP law, it was national law, it was tort law, it was sometimes specific laws, it was common law in the United Kingdom, it was a patchwork of different legislations. And industry felt in today's digitized economy, with people walking around with personal devices, with laptops, with mobile phones, that the theft of digital information was tremendous. People switch employer, they keep their laptops, they go with files back and forward. There is a lot of accessibility from home workers to IT networks of their employer. Companies, specifically in the software industry, there are more and more disputes, not just about copyright infringement, but people running away with IDs, also in the chemical sector, which was better organized, but also there, in some countries, there was a feeling that there was insufficient protection. In the United States, around the same time, there was a feeling that the state law on the protection of trade secrets was insufficient, so a federal law was in the making, and it is therefore no coincidence that almost around the same time, the two big trade blocs enacted legislation. In order to achieve what? A uniform minimum standard of protection. So that means that the member states can always go further. However, the exceptions that are made are also there, and the member states cannot lower the thresholds of these exceptions. Let's look at the definition of a trade secret. If we look at the definition, it's about the only legal text I will bother you with. Those who remember the TRIPS agreement, that was signed by many more member states than just the European Union, will recognize the three basic conditions for a trade secret in TRIPS. In TRIPS, trade secret is listed as one of the IP rights. And here the definition is quite broad. So there are actually only three requirements needed. You must have information, and note information without adjective, so it's not technical information, it is information in the broad sense of the word. That should be secret, and secret is not novel, and by reference to what we heard this morning about designs, it is not as a body or in the precise configuration assembly of its components, generally known amongst or readily accessible to persons within the circles that normally deal with the kind of information in question. So secret information does not mean that it cannot have been disclosed or that it is not novel in the sense that you would understand it for a design or for patent protection. It is a specific standard. But this language is not new. This language comes from TRIPS. It has commercial value because it is secret. That is obvious. It must have a commercial interest. It must not be a military or political interest. It must have commercial interest. And this is then the most important one. It must have been subject to reasonable steps under the circumstances by the owner of the right to keep it secret. I will now make two exercises. I will first go to the labor law implications of this. What does this mean for companies? And then I'll go back to the historical perspective and see what this changes. For companies, this means that there must be an identification of trade secrets. All too often we see in litigation, I'm a litigator, you will hear that from time to time when I speak, in litigation that companies are confronted with a trade secret theft and they only realize that there was certain valuable information when it has been stolen. Yeah? All too often say, oh gosh, we didn't think that this was so valuable, and they act afterwards. The directive, actually, the definition of a trade secret pushes companies to identify beforehand the trade secrets. Know where your information is, identify it, not just make everyone sign NDAs and secrecy agreements, try to see where it is. And then to understand the commercial value, to say what is it important for, why does it have value, and in what products, what does it mean in terms of economic efficiency, where is our trade secret translated into commercial value, and what are then the steps that we actively undertake to protect that particular trade secret. So not again simply have your employees sign a general NDA, but in the factory, in the plant, making specific steps. Closed offices, closed closets, certain files that are marked confidential, specific mails that are indicated highly confidential. You do implement a trade secret policy. I will come back later on this. I will from time to time make a little HR diversion when I talk about trade secrets. But let's go back to the definition. For many countries, just as mine, this is a huge widening of the definition with what we knew before. Trade secrets are protected in many countries as technical information by labor law, and the theft of a trade secret by an employee was considered a theft of technical information. Now, the definition comprises all sorts of information, going from client lists to even algorithms, to commercial information, to business methods, to certain ways of doing business, even to how to approach customers, how to set your pricing. It can be anything as long as it has commercial value. That broadening of the definition was deliberate. And I think it's a good thing because so many companies have trade secrets that are not necessarily from a technical nature, but that do improve their performance and that improve their efficiency and hence their profitability. And therefore, the second condition of the commercial value is acquired. And that's why I think it's a good thing that the definition was broadened, but that's why all the member states need to revise their legislation and adopt this broad definition. And let's go to a couple of examples. And I try to challenge you now and think with me, because if we think of trade secrets, we can have very, very classical examples, but we can also have examples that make our eyes browse a bit. What is that the purpose? For instance, the typical example of the Coca-Cola. I was yesterday here in the bar next door, offered a very nice local drink, which apparently is also a very secret recipe. That's the typical trade secret of it is on sale, but the manufacturing recipe is secret. And indeed, if it's not patented, but you keep it secret, you can protect the secrecy over much longer periods than a patent would do. Cooking books in chemical plants are a nice example. I have enforced patents in Belgium by which I would say the structure of some plants, of some processes, manufacturing processes were protected, the machinery was protected, but what inside the machines was not protected by patents, but was uniquely and only protected by trade secrets. And that works. That works. Certain companies, the big Exxons, the big Shells, the big Air Liquides of this world, they do have a very efficient trade secret tradition. And you need tradition for this. You need years and years and years of implementation and tradition to enforce a trade secret policy. So that works. Formulas to optimize financial instruments in the insurance sector, in the banking sector, they exist. They are not patentable, they are sometimes difficult to decipher, but they constitute trade secrets. Okay, all this falls within the definition, very good. But then, tax fraud mechanisms also fall under that definition. You can make a lot of money with it. Oh, hell, you make efforts to keep it secret, and it is secret. That also falls under the definition of it. Yeah? The Schummel software, those who understand German may know what that word means. What does Schummel software remind to you? Schummelen is cheating. Yeah? Where have we seen cheating a few years ago? In cars, in mobile devices that get electronic upgrades to change the behavior of your product. Rumors go, and it's more than a rumor, that certain brands sell television screens that are programmed to stop functioning exactly when the legal warranty period has expired. It's secret, it has economic value, and God knows that efforts are made to keep it secret. Yeah. So this is a nice example of business methods that comply with the definitions of a trade secret, but that as a society we maybe not like to see. And that's, as a traditional IP lawyer with 30 years of experience, I'm a little bit against this. For me, IP is an exchange between the community and inventors. You contribute technology to the public, and in return, you get an exclusivity. Yeah? Trade secrets divert from that way of thinking, and that's why I'm convinced that it should not be considered as an intellectual property right, and the Commission was very well aware of the fact that it shouldn't, and it stresses a couple of times in the recitals that it is not an IP right. But you see, secrecy and economic value goes hand in hand, but it's not always, I would say, clean or legitimate, and how are we going to deal with those situations? That is the question I'm asking. And let's go a little bit further. And I have asked this question many times already. Please raise your hand or lower your hand spontaneously, react within 3 seconds. Is the following, according to you, a trade secret or not? The CEO, the big chief of a big listed company, has an affair, has a mistress. Is that a trade secret or not? Raise your hand. It's amazing. The more I go to the south, the more hands I see raising. The more I go to the north in Europe, I see no hands. It's really funny. It could comply with the definition of a trade secret. It is secret. It has commercial value if it leaks, and efforts are being made to keep it secret. Is it tradable? Maybe not. This has more to do with the public than with the commercial value. Employees, the HR manager of a company knows that, of BMW, know that most of the employees hate to drive a BMW. Is that a trade secret or not? Shell withholds all information on hydrogen cars, sitting on a lot of information. Are these employees bound by secrecy if they know that Shell has a lot of technology in hydrogen cars that they deliberately do not, Shell, it's pure coincidence, by the way, that I choose this name, deliberately withholding this technology from the public? Is that a trade secret or not? Does it have commercial value? For whom has it value? Can it be misappropriated? Each time, yes, it could be misappropriated. It could leak, it could have negative consequences, but is it falling under the definition of a trade secret, and does it fall under the exceptions or not? By asking these questions, I'm trying to trigger you, to stimulate you. I do not say that I'm having the answers. Going back to the labor law aspects, you should indeed do prevention for leaking trade secrets, confidentiality clauses in agreements, and I will go beyond that later on. The use of a trade secret is considered unlawful when it's in breach of a confidentiality duty or a contractual duty, but you will see that the directive also imposes obligations on someone who should know that the use of a trade secret is illegal, even though he or she is not bound by contract. And this is new, Because in many member states, it was extremely difficult to enforce a trade secret towards someone with whom you have no contractual relationship. There were actually two difficulties, and I will come to the next slide to explain that. Trade secret in most countries was a contractual protection that you had with your supplier, with your customers, with your employees, who stole your trade secrets, and you could go after them on the basis of a contract, but you could not stop the further dissemination or the use of the trade secret by third parties. In particular, in the employment field, your employee leaves, but who is the person who actually uses the trade secret that has been taken away from you? Not the employee, but the new employer with whom there was no contract. And that is a situation that the directive wishes to address. But before coming to that, let's give first my example of the infringing goods to show you where the directive, in my view, has maybe gone a step too far. We have had this question from the Commission members from the very beginning when we had these meetings. I testified as an expert before the European Commission in Brussels. And a lot of, I would say, questions have been asked to stakeholders. The question was, for instance, do you want border seizure on the basis of know-how? And we said, oh gosh, it's already difficult enough to convince customs to do border seizure on the basis of patents that you can read. If you start instructing customs to do border seizure on the basis of know-how, where does it stop? So there was a general recommendation, don't do that. But something was left from the idea of infringing goods. This is a definition of an infringing good. In my view, for those who are patent specialists or patent attorneys, this definition goes way beyond the broadest product or process claim that you can imagine if you want to protect something. It is the design characteristics, functioning, or marketing of which significantly benefit from trade secrets that are unlawfully acquired, used, or disclosed. So even the marketing, if your marketing is a trade secret, it makes the products that are marketed an infringing good. Wow! Can you write me a patent claim? A valid patent claim that would protect that? I don't think so. Yeah. So this is something that indeed is written into the directive. I've been in the committee for the implementation in Belgium. We have been trying to look for ways to get around it. No, the directive imposes the member states to adopt this definition. There is no way around it. This all the member states must implement, but what will we do with it? What will the courts do with it? It is a reach through of trade secret to a particular product or process. Where can that go? And all acts require then knowledge. That's the only difference, of course. It is not an absolute protection as a patent, but the abuse of the trade secret should happen with knowledge. You have this subjective requirement, actually, that make the activity illegal. That's the only higher threshold to distinguish it from a real IP right. But the protection to the good is conferred. And I do give here an example. Suppose that a big supermarket chain has a secret algorithm by which it defines every day the best prices for its dairy products, for eggs and milk and so on. It says, in function of the time, it's warm today, in function of the day of the week and of the hour, we set our prices because we know that our customers buy a lot during those times of the week and less during the other, and they do adapt their prices in function of a certain behavior. Suppose an employee steals that algorithm, goes to another big grocery chain, and that grocery chain starts to implement the same algorithm. Yeah? The trade secret has been stolen. Yes, the algorithm is protected, and maybe the use of that algorithm should be prohibited. But according to the definition of protected goods and according to the protection that the trade directive wants the member states to afford, to make possible, the milk and the eggs and the other dairy products are infringing goods. Those goods should be stopped from sale, according to the philosophy. Yeah. And I gave this example when I testified, and apparently was not serious enough. We go for it. This is something that we have to think about if this definition is not going too far, if it is not going beyond what even a patent can protect. But again, bad faith, there is some knowledge, there is some intent required to make the behavior actionable. And this slide, actually, ladies and gentlemen, summarizes it all. It's a very important slide because I will show you actually what the difference was with the old law of many member states and what this directive actually innovates. You have the first level at the very left, where you have indeed a trade secret that is being devised. In the past, you only could act against the person who had this contractual link, the first red arrow, the person who leaves with the bag. He is bound by contract, and you could actually sue him on the basis of contract. At most, in certain jurisdictions, on the basis of unfair competition, if he had no contract, but he was deliberately stealing your trade secret. That was the first problem. If you had no contract, the protection was very low. Second problem was that in many member states, including my country, it was felt that as soon as the trade secret had leaked into the public, as soon as the trade secret was no longer a trade secret, you couldn't protect it anymore. The court said, sorry, you'd come to me to protect the trade secret, but from your complaint, it appears that it is no longer secret, so I can't protect it. I called that, during my testimony, the ghost in the bottle. The ghost is out of the bottle, and you can't put it back in. Hence, your trade secret is lost. This concept, the directive explicitly deviates from. The directive explicitly allows to sue and to seek injunctive relief against further dissemination of a trade secret, even if the trade secret has already been divulged. It's quite new. That means the trade secret is no longer secret for certain people, but you can still go to court and say, I want to stop it. I want further dissemination to be prohibited. This is new. It's the combination of those two factors is that you no longer should go only towards a person who is unlawfully behaving towards you because you are in contractual relation with him, in combination with the fact that the mere leaking of the trade secret is not a reason to say that it's no longer trade secret. And that allows actually the trade secret owner to go after further parties who are illegally using the trade secret or who are selling products or services whose characteristics are substantially found back in the trade secret. Yeah? On one condition, that there must be knowledge. There must be knowledge is that a third party should know that there is something not right about what he's doing, about the information that he receives. That's the burden of proof that the trade secret holder has to carry, that he must show that there is bad behavior. We are still talking about a tort, about an act of unfair competition. We are not talking about asserting an intellectual property right as a property right, where intent or knowledge is not relevant for obtaining an injunction. And that's how the Commission justified that it is not creating a new IP right with this directive, that it's simply improving and enhancing the criteria for offering uniform protection to trade secrets. I hope you got this message because this is really important. This is nowhere put in the recitals, unfortunately, but it's really the basic difference. The fact that you do not necessarily need a contract and that you can even go after the divulgation of a trade secret after the ghost is already out of the bottle, knowing very well that you can't put the ghost back in the bottle, but you have still a right of action. That is innovative, certainly in my country, in France too. It was impossible to be actionable. Now it should become under the directive. That is really a basic improvement. Now, if you read this directive, there is another thing that as an IP specialist you find very bizarre. We heard it this morning with the designs too. There is actually not a single reference to territory in the directive. Not a single. That means that it doesn't matter where the trade secret was generated, where it was leaked, what is the nationality, the residence, the country of origin of the trade secret. All these terms that we know from the Paris Convention, from Hague, we heard it this morning, all these criteria do not appear. The directive imposes on the member states to provide for legislative measures to protect trade secrets, regardless where they come from. In design rights, for instance, you have the non-registered design right that is available on the condition that the product has been put on the market in the European Union, at the very least. Not in the Trade Secret Directive. So actually, you can enforce your trade secrets in Europe, even if they have never been used in Europe. And what is my prediction is that we may see trade secrets enforced by whom? Yes, by those companies or from those countries who have a long tradition in trade secrets. The United States. They were also the strongest lobbying force behind this directive. Yeah. So you can actually have trade secrets that are generated in the US, that are stolen in China, and all of a sudden, products or infringing acts happen in Europe, and poof, you come to Europe to enforce a trade secret. And the European economy never benefited from that trade secret. The drug or the product in question was never sold in Europe, but all of a sudden that trade secret should be protected. And we drew the attention of the Commission to that. I mean, is there no territoriality requirement for that trade secret right to be protected? No. That was deliberate. And the question is then, what will that mean? Will that mean that this legislation will be used by companies outside of Europe to protect their trade secrets? Even if they have no plans, even if they do not work the trade secret in Europe? That actually, according to the definition, the broad definition, and the definitions of protected rights of unlawful acts is possible. There is never a single reference to the European Union or to any territory in this legal instrument, because it's not an IP right. Yeah, okay, that's the justification. Yeah. That's another, I would say, consequence for which not always companies are aware. They say, yes, we must protect our own trade secrets. Yes, but it can well be that you are contaminated by a trade secret that is coming from China, from a Chinese employee who you hire, and he, on his turn, has stolen it from the US. And all of a sudden, you have a US company suing you in Europe for something that you say, where is the origin of the technology? Okay? Just wanted to make that point. And I raise it with even more emphasis because our American counterparts did not go so far. In their definition of a trade secret, they do make a link with the United States. Yes, you can act against activities outside the United States, but then it must be related to a trade secret that is related to a product or service intended for use in interstate or foreign commerce. Yeah? The definition is also so that the CEO has an affair could not be protected by a trade secret because the definition of a trade secret must relate to a product or a service. So there is a territoriality requirement in the United States federal legislation that is more restrictive than the European one, and it must pertain specifically to a product or service. I think that is important to make that comparison. And then you also have the US Economic Espionage Act that also makes a clear link to the United States, and only when the espionage or trade secret theft relates to activities outside the United States, it must be stolen, or the offender must be a natural person who is a citizen or a permanent resident alien of the United States. And those conditions are not in the Trade Secret Directive. So actually, a Chinese company can sue an American company in Europe for theft of trade secrets that are originated outside Europe. So all these nationality requirements or territoriality requirements are not in the directive, whereas the United States, who is a champion in trade secret enforcement, I would say, if you compare it with our jurisdictions, they do have those restrictions. And then the ex parte seizure, that is something that I think, fortunately, we did not put in the directive, but that exists in the United States. I seem to believe, to hear that this is not very often used, but it is available at least under the law. If we go then back to be loyal to the title I was committed to speak about, what about how should companies prepare for the trade secret protection? The reasonable protection, that's in the directive too. We have had the meetings with the Commission members now a year ago, where the criterion reasonable is going probably to vary according to sector. Maybe a pharmaceutical company will have a higher standard to be reasonable in the steps of protection than a software company, where people go in and out, maybe much more easier than in a pharmaceutical company. What do you do with designers in the fashion industry? And what do you do with designers in the automotive car industry? Should you put the reasonable criterion on the same footing or not? Probably not. The Commission told us that they're working on a group and sort of the help desk that will elaborate more standards to see what that criterion of reasonable could mean. And the proportionality is written into the community text in that the courts can always enforce or perform that test. The test of proportionality means that you are going to apply the law taking into account a number of factors specific to the circumstances. The role of HR, I already emphasized this. It is not enough to have guides. It is not enough to have rules in the company. You must really have very specific policies whereby certain personnel is not given access to certain information. You really must implement this. Very often today, this will be implemented through IT systems, to access with passwords and with monitoring. It is it is a coincidence, but it's very important that in the coming 2 months, 2 major pieces of legislation will start to come into force. That is, on one hand, the trade secret protection, and on the other hand, the GDPR, privacy rules. Privacy rules will become much stricter. If companies want to monitor the use of their trade secrets, who is going to run away with certain files, who has had access to confidential information on a server, they must make certain that their IT systems are also GDPR compliant. It's a double challenge, actually, and it goes hand by hand. If you want to make sure that your trade secret policy is respected, you must also make sure that the tools that you put in place to make them respect and to monitor your employees, that they are trade secret compliant. I think that one of the biggest challenges will be in inventorship, keeping track of inventorship of companies for patents. Because typically, inventorship of patents, you must keep those things on file for 20 years. Because most patents get most valuable at the last 5 years of their existence, certainly in pharma and in biotech, and the employees have left the company when the patents become really valuable and you start to assert them. If then inventorship issues arise in court, and you must prove it, but the documentation you have, you no longer have it because on GDPR you had to delete it, or the former employee is now member of your competitor and he says, you can't use the data showing my inventorship because I never gave my consent, then you are in deep trouble. And there I think GDPR, trade secrets, and traditional IP law will need to be combined, and a company will need to develop a good strategy to protect its trade secrets, to protect its personal data, and to see where it can either develop IP rights or trade secrets that are stripped from personal data, so that they do not have to bother with GDPR. Unfortunately, certainly as far as patents go, you cannot strip personal data from a patent. A patent must have an inventor, and that inventor must be identified, and his data leading to the invention must remain available throughout the lifetime of the patent. That is not a trade secret, it is GDPR relevant, But how do you keep all these three things in balance? That's a challenge, and that's something I think that companies will need to work with in the coming months and years to implement both the trade secret laws, GDPR, and taking into account the already existing regulations in patent law. Then I come to the exceptions. I mentioned you in the few months before the enactment, there was all of a sudden some political awareness, certainly in France, that this trade secret directive actually created new rights for trade secret owners, but that any information could be stifled, could be stopped from putting into the public. And what do we do about freedom of the press? Can journalists no longer bring out that the CEO has an affair? Can journalists no longer bring out that Shell, again, this is by pure coincidence, that companies do nasty things to the public? Can companies no longer say you have an upgrade on your iPhone that actually makes sure that it no longer works when the warranty expires? That's a trade secret. So you can go to court and stop the publication of a journal. No. Some checks and balances were built in also for trade unions. Members of trade unions, trade representatives, can have access to trade secrets. That access is legal under the directive, and the use of those trade secrets in the negotiation process within the company is allowed. Typically, in plants, for instance, in the automotive, where will a company build its new plant? In what country, in what city? That is very, very, very sensitive information, politically also very sensitive. Will a company close? Will a company move its plants? The unions must have access to that information in order to negotiate. So these are two exceptions. I only stress the one from the labor unions here that were put into the directive almost last minute, almost a month before it went to the European Parliament for adoption. Those texts are not perfect. We decided even in Belgium, where I was a member of the committee implementing it, that we would not deal with it. It's a different law. Let's put that into labor law, to collective agreement law. But in a trade secret law, how do you deal with it? The provisions are there, but it's difficult to implement because each country has its separate legislation regarding freedom of press and the rights of labor union representatives. But those exceptions that were built in very late show that there was awareness that this directive actually stifled the freedom of communication of certain actors in social life that were not anticipated in the beginning. Everything was in the direction of trade secrets ought to be protected, yes, but what for the general public? What of the right of information? What of the right for workers to negotiate, for unions, and also for workers to move around? Because that is another problem, of course, that this directive imposes a pretty heavy burden on companies when they go into a recruitment process. When you do recruit a highly trained technician, a highly trained scientist from one of your competitors, you better screen what that person knows, what that person shouldn't tell you, and what that person better keeps in his old employment or even forgets. And that's the big problem. You cannot forget. You cannot empty someone's brains. But that is here the problem. How do you prevent that trade secret laws are being breached, and at the same time do you promote employee mobility? That was the last concern that was subject to debate in the weeks before the directive went for adoption to Parliament. And there is actually, I'm going to skip a bit because this is more labor law. There are many problems with the bring your own device policies. Many employees have their personal laptop, have their personal database, have their personal contact tools, have a lot of information on their devices, have had access to a lot of information. How do you strip that information from an employee if he leaves the company? In biotech and in pharmaceutical, that tradition exists. These companies know how they should approach employees when they leave a company. They make them sign detailed agreements. Some of them do. How are you going to implement that in the day-to-day business of a software company, of a fashion designer company, of a company of the type of thing that I gave you earlier about grocery stores? How will every HR department of a company start to talk when his employee leaves to the competition? Shall you empty his or her brains? Shall you make him sign a confidentiality agreement? Making him or her sign a very broad agreement doesn't make sense. You need to identify the trade secrets. How do you identify that? Will you call it by project name? Will you do it by referring to certain patents? Will you say this technology is proprietary, you cannot work on projects in the other company? You will probably have to negotiate a very detailed non-compete agreement, and you can do that from now on because the tools that are given to the trade secret holder are no longer limited to sue the former employee. Very often you advise to your client, don't sue the former employee. Even if he caused you millions of damages, the poor guy can never pay you back. But from now on, you can attack the new employer. Aha, there is a deep pocket defendant, so the millions all of a sudden might be recoverable. This is the new route that the directive offers and forces the member states to implement. So there is a lot more incentive for companies to enforce their trade secrets because they no longer must go after the former employee, but they can go after the new employer. And then, of course, it becomes very important, both from that former employer and the new employer, to know exactly what is a trade secret, what is, and here comes then the important word, the honestly acquired skills. That is in the directive too, that no action can be taken against use by employees of experience and skills that are honestly acquired in the normal course of their employment. That definition seems to come from British case law in labor and know-how disputes, where the difficult balance must be drawn between the rights of an employer to say, this is my confidential know-how, this is my trade secret, but that trade secret most often has been built up in the mind of 2 or 3 highly trained, highly experienced senior employees, and if they leave, what are you going to do? How are you going to empty their brain? How are you going to refrain them? That is an exercise that in certain industries, I repeat it, is not unusual, but that from now on, we can generalize in all practices, in all industry practices. And that was the purpose of the directive, to enhance, increase that awareness, but at the same time, European Parliament pushed very hard in the last weeks to introduce that line. That line was introduced only a week before it was adopted. There was some lobbying, particularly by French government and Belgian government too, to put that in. Otherwise, indeed, employee mobility would be restricted, was the argument. You want to make sure that scientists can travel freely around from one company to another, but if trade secret protection becomes so powerful, then actually a new employer doesn't want to hire him anymore unless he takes an annual leave for a year or so, or he forgets you brainwash him, which you can't do. This is all very vague, and as you know, with European legislation, the terms are always very broad, have to be filled in by the European Court of Justice and by the courts afterwards. So we are looking to very new fields of law. And so we will have to see how this works. In the national implementation phase, and I'm sure, Mr. Chairman, I don't know how much time is left to me. Another 5 minutes, or? Yeah, I'll talk about national implementation, and I'm sure now later we will hear about how it goes in this country. The ones who are first ready are the Dutch. The Dutch have their law ready. I read it this morning, and actually they go beyond what the directive states. For instance, what they do, they make available their famous procedure of evidence seizure to holders of trade secret. In Belgium, we refuse to do so. We have a very efficient procedure of seizure of evidence for all intellectual property rights. Belgium is even more famous for that procedure than for what the courts do on the merits of the case. But in Belgium, it was explicitly decided because of the risk for abuse of those proceedings, for a very blurred and undefined, self-defined right of trade secrets, we are not going to open that procedure for trade secrets. In Holland, they will. In the Netherlands, for instance, also, they have a very broad statute of limitations. So the trade secret owner who is not aware of the fact that his trade secret has been stolen has actually a statute of limitation of 20 years before he can act. The directive, and this is something very strange too, the directive says that for infringement that the trade secret owner should have known or becomes aware of, the member states can regulate the statute of limitations between 3 and 6 years. 6 years is the maximum deadline for a trade secret owner to act for when he knows that there is a violation. Belgium will probably adopt 5, the Netherlands have 6. These are issues that the national legislators can still deviate from. And for instance, in Belgium, the general law is 10 years in torts. In Holland, it's 20 years. That means that you can sometimes enforce trade secrets even after 15 years when you can show that you didn't know about the abuse of the trade secret. It's long. It's pretty long. Other issues are, and this is a typical issue for France and Belgium, I don't know how in this country, but employees have a specific enforcement regime for the courts. There are specific labor courts who have exclusive jurisdiction about all issues arising out of the employment contract or issues arising out of the employment, of the former employment, until 1 year after leaving your employment. Whereas you would want to put this sort of legislation and enforcement in the hands of more specialized courts. In Belgium, for instance, the IP courts will deal with trade secret violation, but how to deal with the labor courts? Will you have competing jurisdiction? That means that, as is now the case, you will have to litigate twice. You'll have to litigate once against your former employee and then once against the new employer. That's double litigation, that's double costs. Those discussions are going on in a few countries and make it more difficult why sometimes the law is not yet there. The whistleblowing legislation will also need to be enacted. How can you allow someone in the company to whistleblow if that topic of the whistleblow is a trade secret? The directive says very generally that the member state should provide for measures, and they leave that to national legislation. Experience and skill, and you cannot take away experience and skills. How does that relate to know-how? That is a specific problem. The directive also imposes, and this is very important for litigation purposes, that the courts must provide for confidentiality measures during litigation. The use of confidentiality clubs must be allowed. That is, that lawyers and parties make agreements whereby they can exchange trade secrets or proof of existence or leakage of trade secrets, and that information cannot be spread around by the parties themselves in the company. This, until now, only existed really in the United Kingdom. And that is by coincidence not the only country where there was effectively some trade secret litigation, effective trade secret litigation. Now all the member states will need to implement this. It's not easy to do that because this goes way beyond legislating in the law. This goes into regulating the rules of procedure of a court. And that is also a point where many countries struggle. For instance, the Belgian law that is in the preparation doesn't say much about this because it is very difficult to say something in general terms. Yes, you have secrecy in competition matters. You sometimes have secrecy in patent matters. But how to impose general confidentiality undertakings? The Dutch said, we will impose a new regime for all litigation. So they did it the horizontal way, which is probably the good way of doing it, but you need political courage to implement that innovation. And shall you have centralization or not? Shall you leave it to the regular commercial courts the 5 or 6 that you may have in your country, or shall you put it all in the hands of a single court? In Belgium, it's going to be Brussels. In France, it's going to be Paris, like they did with the IP courts. In certain countries, they're going to leave it to certain specialized courts, most likely the IP courts. Yeah. And then how to deal with trade secrets and the data economy. How shall we allow free trade of data and at the same time protect trade secrets? How shall we allow that the Googles and Facebooks of this world, but let's not take those only as examples, but companies who are sitting on a lot of data, can actually sell these data without being hampered by people who say, yes, you are selling my data too, but there is a trade secret in there. I made them available to you, but I do not allow you to sell them further, even if they have been stripped from personal data, anonymous data. Are they a valuable asset that they can be sold or licensed, or are they a trade secret where the originator has a right of injunction on? These are issues that are known in the pharmaceutical industry, where there is always a balance to be struck between the public health and the owner, the interest of the trade secret owner. But how are we going to implement this, for instance, in the fashion or in the software industry? It's not easy. All this was not being thought of. And how could you if you have put this legislation together in less than 3 years? Yeah? All these things have to be thought about, have not been considered, but the text is there. At least it's there, and it has to be implemented. The UPC, we're waiting for 40 years and still not there. So I'm not too critical about this, but I say there's a lot of work going ahead and a lot of work for the courts and the legislators to put this forward. The bona fide infringer is also something that is new. So you can be a bona fide infringer. You are using a process. You got it from an employee, and you thought that he was totally legitimately developing that technology, although actually he got it from someone else. There, the directive imposes a duty that you can at most injunct the person, but you cannot hold him liable for damages. And even the injunction is in certain circumstances restricted. You can not injunct them, you cannot get damages, only a reasonable royalty. How are you going to implement this? What are going to be the criteria? That's another thing that the directive imposes. The statute of limitations, as I said, maximum 6 years for if you know that the infringement took place. In the Netherlands, it is 20 years. And the national law, and this is very strange, the national laws can diverge on this point. So there the European Commission did not get political consensus, and all the member states have freedom to set their own laws. So if you say the good points and the bad points of this directive, and having witnessed a little bit the legislative process over the last 3 years, I would say it's very good that you have a uniform level of protection. That was probably badly needed. And no coincidence that in the United States they did a Federal Trade Secret Act around the same time. You have better procedural tools in litigation. That need was felt, not only for trade secrets, but for patents in general and for other types of technology litigation. And the definition goes beyond technical know-how. This is definitely something that had to be recognized, that today intangible assets are no longer just about technology. We all know that value is beyond technology. Just the data, personal data, have value as well, even if they have absolutely no technical merit. But will it be abused? Are there enough deterrents against abusive litigation? Will our courts be overwhelmed by the Koreans, by the Japanese, and by the Americans? Don't know. That definition of infringing products, as a patent lawyer, it gives me the shivers. I don't like that definition at all. I hope it's not going to be used too often. And as I said before, will this legislation actually be more a threat to European companies than a tool that European companies can increase their own competitiveness? Or will they be more attacked by non-European companies by asserting trade secrets that were never worked or never generated in Europe at all? That is my last concern. And with this, I conclude my presentation. Thank you.
Paldies Vandermēlens kungam. Jautājumi? Būtu kādi jautājumi tagad uzreiz? Jā.
So thank you really a lot about the explanation of this new directive. It broadens my mind and also maybe gets me about thinking of those things you said. Two questions maybe. Does the trade secret also defines like idea of how we're doing something? For example, we say that idea to produce one product is to freeze it with nitrogen, and it's just an idea. Then technical realization is building a machine, building something which can be patented, but it is not so important that we protect the technology, how we freeze it, but the information that we are choosing to freeze this product, for example, prior to production. So would it be also something intellectual property, or how it was the trade secret? And the other question, maybe just so that I confine it, when the directive is started to be working within Europe, does it also concern the cases that is before the directive is starting to work?
Yeah. Your first question, I think that the definition, the three criteria of the definition would lead to me to the conclusion that the type of ID you're talking about that has never been implemented, that just in the head of a couple of employees but never put to practice, has no commercial value. It maybe has a potential value, but it would probably be more criticizable to consider as a trade secret because it's something that's in the air. Different to a patent, you can indeed patent something, file it, and start using it only after 15 years when you are able to to put your idea into practice, and that is why patents are so useful. I think that's where probably the definition would make that this sort of phenomenon would strand. That would be my reaction, that the commercial value would be considered too low. Yes, you have the idea, but you do not make money out of it. So the dissemination will not cause you commercial harm. That would be my reaction. But you may disagree with that, and
yeah, maybe I didn't explain it correctly. So basically, I mean that with this idea, what company has, it has a capability of produce a product that no one can. And it's done only on the basis on a simple idea, and I'm thinking of it's already implemented. So we implement, for example, it's not that we do it, it's just a good example of what could happen. So we implement it, maybe we choose to patent this technology, but now we wouldn't choose the patent technology because competitors, after we have done and they see that we have this product, would know by the idea that we have this cryo cooling system and we have this product, they would simply put it together and say, okay, we also will develop something like this.
Yeah, yeah.
So, but if the employee who's working within our company goes to some other company, he knows this idea and he knows why we want patented, and he says it. It's just simple sentence, for example. And this would lead to catastrophic, like a huge impact on our product portfolio and the pricing.
Yeah, the simple sentence is a trade secret. The fact that you do know that Volvo is going to close a plant there and going to remove it to another country is a trade secret. It's a simple line, but trade secrets can be as simple as a one-liner, shorter than a tweet. That I'm convinced about that. And how do you ensure that that sort of trade secrets are not being breached? So I think it's not the simplicity or the non-putting into effect of the idea that prevents it from being a trade secret. It's all about what is the commercial value. Does it have commercial value if you divulge it or not? What can your competitor do with it? Probably it will strand there, or it will indeed be very valuable. Your second question, sorry, I forgot.
Yeah, it was about the cases which are before the new directive comes into the...
There is absolutely, again, there is no territoriality restriction, and there is certainly nothing in the directive that says trade secrets must have been put in practice now. No, you can immediately start enforcing trade secrets that are decades old. Yes. Yes. There is absolutely no criterion. It was to protect the existing trade secrets that this legislation is enacted. Oh, yes. Except for the statute of limitations, of course. If, for instance, there was already 6 years knowledge, then you are barred. but there is certainly no rule that says, and you must have now developed a trade secret as of now.
We have one more question.
Yes, hello again. One more question. Bearing in mind these issues you raised regarding trade secret, no territoriality, perpetual protection almost, do you expect that the number of patent applications will significantly drop after the implementation?
I don't think so. I have given once a very presentation with a patent attorney to trigger a bit the audience to say, will trade secrets become then the better alternative for patent protection? I don't think so, but I think it may probably lead to companies being better aware of certain processes that they can maybe better protect via trade secrets, and maybe some patent owners may decide not to keep certain patents too long and to focus their improvements on secret technology. I don't think this will lead to a decrease in patent applications. I think it will just be an extra layer of protection that will be created, except in that area where certain improvement processes can sometimes be better protected via trade secrets than via patent applications. But I think that's a relatively small area, and it was certainly not the aim of the directive to provoke that. The aim of the directive was to create awareness of trade secrets in those technology sectors who until now have no clue at all of what they're doing. The software industry, the fashions industry, the trade, banking and insurance, that they start paying attention to all this.
Paldies. Vēl kādi jautājumi? Laikam nav. Tad paldies vēlreiz Vandermēlens kungam. Thank you very much.